Welcome to everybody who's joined us this afternoon. Just going to wait another 30 seconds to see if anybody else is joining us, and then we will get started. Okay, so conscious of time, and we've allowed half an hour today, and conscious that everybody's time is quite precious at the moment. So welcome all to the Just Legal Sector webinar on virtual enforcement, which couldn't be more timely with Step Change and 13 other charities calling for the government to stop doorstep visits, with the latest suggestion being lockdown will continue until late March, with continued tier restrictions post-lockdown. So taking you through today's 30-minute session is Nick Georgiadis, our Managing Director at Just, Chris Badger, our Director of Legal and Compliance, and last but by no means least, Natalie Tate, Director of Operations. So you'll have plenty of opportunity to ask questions throughout this webinar. In the right-hand side at the bottom, there is a Q&A button, so please just post your questions there and we will get to them at the latter part of the webinar today for you. And we will also, if we run out of time, we will send you out an FAQs document after this webinar. So let me just run you through the agenda for today. So we'll go through the background to the concept of virtual enforcement, the legal standing around that, where virtual enforcement sits as an enforcement option for you, when it should and shouldn't be used, how the process works at Just, and then how virtual enforcement can help you. So as I say, we invite questions throughout the webinar and we'll try and pick those up towards the end. So without further ado, I'm going to hand over to Nick.
Thanks, Vic. So firstly, welcome and thank you for attending this. So a background to the concept of virtual enforcement from us was that back in March, when the first lockdown started, we had plenty of time on our hands to consider how enforcement could change and would need to change in a post-COVID world. And more recently, we've realised that the tsunami of debt that is going to flow through, with a lot of industry speculators saying there's going to be up to 400% increase in the amount of debt that we will, as a sector, have to deal with. And the enforcement industry has been around 2,000 agents for the past decade or more. That's not going to be able to increase to 8,000 without significant risk. Added on to that, a lot of these people going into debt will be going into debt for the first time. They won't have experience of dealing with it, and it will be a very stressful situation for those type of debtors. Many of them will want to pay the debts. They'll just require a little bit more time to pay them, and they won't want to live in fear of visits and additional fees that makes it unaffordable. So to deal with this increase in demand, we realise you need to do something significantly different. So during a virtual team meeting, we came up with the idea of maybe we could do a virtual enforcement visit. This would allow bailiffs to work from home, which would mean they could conduct far more visits, and that increases the capacity. It would be able to protect creditors' rights by them able to get a payment plan against a controlled goods agreement. This in turn protects the debtor from subsequent aggressive bailiff action or further removal of goods if they're already secured. And as I said before, we charge no fee for the virtual enforcement visit, so that saves the debtor substantial fees. We save them substantial fees. That means more of every pound collected will go to paying the creditor off, which means you'll get your money quicker and the debtor will get out of debt quicker also. And after all of this, it actually shows that we're developing as an industry, you're developing and taking into account the current situation to show stakeholders that we are thinking about how we do this appropriately in the current situation. Now, I'll pass over to Chris, who'll give you a bit more information on the legal case that got through, that gave us authority or confirmed authority to do this.
Thanks, Nick. As Nick has said, we developed the virtual enforcement concept during the first lockdown period. We consulted very widely with a number of stakeholders, including the Ministry of Justice, but also the likes of Step Change, the Citizens Advice Bureau, and the Taking Control Group. The MOJ's position was one of steadfast neutrality in relation to whether our concept of virtual enforcement was within the scope of the rules and regulations that govern the enforcement process. In view of this neutral stance, we decided to ask the court to scrutinise our proposal, and we achieved that by using the CPR Part 8 procedure. As you can see from the sealed order on the slide, Master McLeod made a declaration that permits a High Court enforcement officer to enter into a controlled goods agreement whether or not his or her enforcement agent has entered the premises. These were lengthy proceedings with extensive submissions by Just as the applicant and also by the interested parties that engaged in the process. In her judgment, Master McLeod held that Schedule 12 of the Tribunal Courts and Enforcement Act does not prohibit virtual visits from being undertaken or remote entry into controlled goods agreements. And again, this is reflected in the declaration. In her judgment, the Master made a number of findings, but there are 6 important ones that I will call out here. The first is that the exercise of the enforcement power is governed by Schedule 12 of the Tribunal Courts and Enforcement Act. The second is that an enforcement agent may enter premises, but not that they must do so. The third was that the Master considered in judgment the case of Hanlon versus the Law Society and concluded that whilst regulations created contemporaneously with an act might inform but did not decide or control its meaning, and that's considered in reference to the matters arising from the taking control of goods regulations and the associated fees regulations. Fourth call out was that the regulations stood alone and were evidence of the view of the legislature at the time as to what roles it thought appropriate to put in place pursuant to the Enabling Act, and in this case, that's Schedule 12 of the TCE Act 2007. The fifth point was that the powers dealing with entry at paragraph 16 of Schedule 12 and the forced entry provisions at paragraph 19 would not apply where a non-entry controlled goods agreement is entered into, and in judgment, the Master made the distinction between the two forms of agreement. Sixth point relates to function, and that was that the Master determined that the court's function is to interpret legislation, but that it was for the Lord Chancellor and the MOJ to address matters of policy. Ultimately, the declaration brings clarity to an area that has been subject to much debate within the enforcement sector over the last 12 months, and in particular during the numerous lockdown periods. And what this judgment does is it provides a common law authority confirming that the act of seizure is permissible using video technology. And that's at a time where government has prohibited, by way of its guidance, physical entry by enforcement agents into residential premises. I'm now going to pass back to Nick, who's going to talk about where virtual enforcement sits as an enforcement option.
Thanks, Chris. So now what this judgment has allowed us to do is offer debtors and creditors a third option when agreeing to extended payment plans. The two that already existed and will continue to exist are you can perform a physical visit to secure the plan against goods and charge the debtor in the region of £200 plus, or you can accept a payment plan without security. They will continue to exist and in the right circumstances will be appropriate. What this adds on is another option, which is you can complete a virtual visit, secure the plan against goods, and do that for free. So what this does, it gives the creditor the protection and the debtor the protection of the controlled goods agreement. In all of these options and throughout the enforcement process, as everyone would expect, you constantly be using data and analytics to ensure that you're getting the payment plans appropriately. So the likes of open banking, open accounting will be used for affordability, and you'll identify vulnerable customers throughout all of these processes, as an enforcement industry currently does, and pass them to or signpost them to relevant people who can support them, such as Mind and Step Change that we partner with. So what I'll pass you over now to Natalie to talk about when virtual enforcement is appropriate and when it's not.
Thanks, Nick. Okay, so Nick's talked about where virtual enforcement is appropriate. Let me talk a little bit more about when we believe virtual enforcement should be used. Naturally, virtual enforcement lends itself better to some types of portfolio or case better than others. Firstly, let me stress here that a client can consent to virtual enforcement at either an individual case level or indeed a portfolio level. We're currently working with our existing clients to analyse their portfolios to identify cases where we believe virtual enforcement is both proportionate and effective. We would happily conduct that exercise for any prospective client portfolios too. Second point to make here is that in our collective experience of working in the debt industry, we have seen time and time again that tailored treatment paths reflective of circumstances will always outperform vanilla one-size-fits-all treatment paths. It's important to see virtual enforcement as an additional tool to solve a bad debt problem rather than the replacement of an existing one. When used properly, it's proportionate and effective at driving the right outcome for both the creditor and the customer. Much of this is determined, however, by the type of customer you are dealing with. So those who want to enter into a payment arrangement are keen to ensure no further monies are added to the balance and want resolution to their debt. This is a great innovation for those customers. Also, to Nick's earlier point, this is great for customers where we need broader considerations with regards to their vulnerability. Again, the belief that a virtual visit can lend itself to customers' personal circumstances better compared to a physical visit. There's also the obvious factor today whereby EAs can currently visit residential addresses, but they cannot enter those premises. Clearly, with virtual enforcement, our enforcement agents are able to verify the nature and condition of items secured against a payment arrangement, whereas with physical enforcement, you currently can't. So we use a mix of data and detailed conversations with customers to determine the appropriateness and effectiveness of virtual enforcement. In contrast to this, though, let me be clear that there are cases where physical enforcement will always be the most proportionate and effective means of collecting debt. Cases that carry higher risk, driven by either the balance, the nature of the goods that could be seized, or indeed the time sensitiveness of the case, are all factors where we would recommend maintaining the use of physical enforcement. We've put significant work into the processes and structures of the conversations we have at head office level to effectively assess the can't pays from the won't pays. If we move on to the next slide, I'll talk a little bit more around this. So, how does the process work at Just then? Consent on both sides is central to the process at Just. So, as I mentioned previously, the creditor giving consent at either a portfolio or case level is where the process starts. This then triggers Just to engage with the customer to talk of the merits of virtual enforcement. Once engaged, we have a detailed conversation between the head office team and the customer. This is heavily focused here on the consent and the willingness of the customer to put together a payment arrangement that covers the balance. This conversation falls broadly into three parts. Firstly, there's the consenting to the virtual visit itself. This includes details of how it's recorded, the storage of that data, and actually how that session will actually be conducted between an enforcement agent and the customer. Secondly, there's the agreement of a payment arrangement. Again, significant work's been put here into developing robust and effective conversations with customers about their debt and their repayment options. Clearly, this leans heavily on the benefits of getting a payment arrangement in place and clearly the consequences of non-payment. Wherever possible, we will always push to take that initial payment there and then on that call. If these three things are successfully in place, it is at Just's recommendation that we schedule a virtual visit and we halt any physical enforcement. The final step in the process, you could say, is the simplest, and that is the virtual visit itself. Conducted through our enforcement agents, this is focused on the verification of the goods, basing the conversation around the draft control goods agreement that's been put together at head office level. If the goods are successfully verified, the final control goods agreement is sent to the customer and stored at Just. Again, throughout this process, the consequences to the customer are made clear. The default activity will always be physical enforcement if we don't believe the customer is willingly engaging in the virtual enforcement process. I hope you can see from this that the virtual enforcement process is far more detailed and robust than a simple video call that ticks boxes to say that we know goods to be in existence. Not only is it robust, it's been diagnosed to specifically drive the right outcome for a specific type of customer. One final point I'd like to make on this slide before we move on is the decision we've made as a management team that for now we will quality assure 100% of both the head office conversations and the virtual enforcement sessions. The first time this industry has seen that amount of assurance into the quality of conversations, but also a reflection of our desire to really provide insight and assurance to our clients, the industry, and to ourselves that this process is effective and proportionate when conducted correctly. I'm going to hand back to Vic now, who's going to talk in some more detail around the benefits of virtual enforcement in your organisation.
Thanks, Nat. So, enforcement can help you as the creditor. Ability to continue effective enforcement during these uncertain and COVID-19 times. It gives you the security on payment plans without the risk of person-to-person contact and the associated fees that come with a physical enforcement visit. Having your payment plan secured means that more aggressive creditors cannot take or secure your customer's asset, causing your plan to fail. So we're talking about priority order here. Less fees payable by the debtor customer means more people can afford to pay, and more of what they do pay is returned to you not having to pay off the costly fees that they have on top of that principal balance. And I think it shows the ability to your key stakeholders, your clients and your regulators that you have made effective changes to your enforcement policy as a result of COVID-19. So what does that mean for the debtor and customer? It's the ability to request extended payment plans without accepting that a bailiff must visit first. So giving them options. Ability to give a secured payment plan protects their assets from subsequent more aggressive bailiffs and the associated fees. So again, going back to that priority order. Less fees payable means better ability to pay, not just you, but other creditors. And less fees mean they can get out of debt quicker and pay less overall. And they're not forced to accept the risks associated with person-to-person contact and COVID-19, particularly where they're vulnerable. I'm going to hand back to Natalie.
Thanks, Vic. There's just some closing remarks from me, really, to give you a flavour of what we've learned so far. The judgment was handed down from Master McLeod not last Friday, the Friday before. And prior to that point, up until now, we've been doing extensive testing both with enforcement agents and customers. So a couple of things I want to draw on of what we've learned in that time. Firstly, let me start with some feedback from the EAs. As we've said previously in the call today, due to the COVID restrictions, an EA can currently visit a residential address, but they cannot enter. A light bulb moment for us has been using virtual enforcement is the first time for a significant period of time that an enforcement agent has not only been able to put together a controlled goods agreement and agree a controlled goods agreement, but through seeing and verifying actual goods in someone's home. So for residential properties, we now have better insight on the goods, the grading of them, and the customer's willingness to commit to a payment plan. And we believe we've got better value in that than anyone else in the marketplace currently. Finally, from our testing at head office collections, we believe that our conversations are significantly more robust now they're hinged on the compilation of a controlled goods agreement. We believe that these will perform significantly better than standard compliance conversations too. That's everything from me, Vic.
Great, thanks, Nat. So that concludes the first part of our webinar. So it gives us quite a bit of time to go through the questions that have come through. We've got around 8 that we need to answer. So let's start with the first one. So how do you know that they are at their home and are not at a friend's house? And how do you know that the debtor is actually showing you the goods? I think that is a good one for you, Nat, to answer.
Sure. Yeah, that's fine, Vic. We've discussed this a lot as a team. This starts again with those very robust conversations we're having at head office level. And arguably before that, actually, in the data we are using to figure out which customers does virtual enforcement lend itself to and which ones doesn't. So held firm in the belief that this is designed for customers that want to engage with us willingly, they want a resolution, they want to clear balances, and they don't want further fees adding to their balance. That conversation really weeds out the won't pays from that part. Secondly, let's talk about the experience of our enforcement agents. It's still a qualified enforcement agent that is conducting those virtual sessions. So it's the experience we draw on there. And one final point I will make is the consequence of non-compliance with this. So a worst case scenario, you have a customer that does not willingly enter into this. We are unable to verify goods. We simply default to the physical enforcement process that this industry has been using for hundreds of years.
Thanks, Nat. So the next question that we've had come in, does the MOJ need to write guidance or change regulations before it can be used? Can I defer to you, Nick, on this one?
Yeah, sure. So I think this is in 2 parts. For how we're doing it, absolutely not. So it's very clear from the judgment that you can take a controlled goods agreement without entering the property, and that's what we intend to do. I think there are some calls for guidance, but they're predominantly for two things. One is if you want to charge a fee for doing this, I think there needs to be a call for further guidance. Two is if someone broke the plan and you wanted to go straight to force entry, then we would need further guidance. At Just, we're not doing either of those. So the solution that we're adopting and how we're adopting, absolutely not. We don't need any further guidance.
Okay, so we've got another question. If the debtor agrees to the virtual enforcement, is there any possibility for him to contest this enforcement if he doesn't agree? And yes, how? Same as, can he do this as a judicial officer? You just go into the premises and can make an enforcement. I think I've read that correctly. Who can I defer to for that? Can you be able to pick this one up, Chris, for me?
Yeah, thanks, Vic. Yeah, as Nick alluded to earlier, there are two approaches when when we find ourselves in a situation where we have a breached agreement. The first is the rules make provision for an application to court. So we can make an application probably to a master in the Queen's Bench Division, setting out that we've taken or entered into a non-entry controlled goods agreement, and ask the court for permission, formal permission, to the High Court enforcement officer or the enforcement agent to force entry to those premises. However, I think what's more likely is that an enforcement agent would make just a regular attendance, a standard attendance to knock on the door. Although, notwithstanding those 2 points, I think what's more likely is we would engage in telephone, email, those sorts of forms of communication to endeavour to touch base with the defendant, possibly even another virtual call to try and engage, try and establish why the arrangement's been broken, and to establish whether there's some scope to realign and restore the defaulted payments.
Yeah, sorry, Chris, I think I might just have to redo that question. So if the debtor agrees to the virtual enforcement, is there any possibility for him to contest this enforcement if he doesn't agree? And if yes, how would that be?
Well, the judgment makes it very clear that this is a consensual process, so it's by consent. So we think it's very unlikely that there would be any challenges. But if there were a challenge to, let's say, the validity of a controlled goods agreement that's been achieved virtually, then the same as in any other instance, the customer has the right to make an application to court to formally apply for an order to set that aside.
Thanks, Chris. So how does the debtor sign the controlled goods agreement at the conclusion of the virtual visit? It's an operational question here, Nat.
Sure. Quick answer to that. We're using DocuSign to electronically store customers' signatures and consent. So I'm sure everyone on the call today will be familiar with DocuSign and how widely it is used across multiple industries.
Okay, I think we've got time for a few more, which is good. So does the £90 compliance fee still apply?
I'm happy to take that. So for us, yes, we're talking about no additional fees, so no enforcement fees. The compliance fee does still apply. The only thing I would say is, don't charge VAT on that. So it's actually we charge £75 compliance fee for High Court writs to the debtor. but yes, it does still apply.
Well, I'd just come in, Vic, and just to add to Nick's answer, to say that the virtual enforcement visit, it takes place in what those that are familiar with the fee structure is at enforcement stage 1. So whilst the compliance fee is still incurred, the enforcement stage 1 charges, which are in some instances quite substantial, it is those fees that don't apply to a virtual visit.
That's great. Thanks for that clarification, Chris. So I think we've got a couple more. So I think we can probably just finish off. How does virtual enforcement interact with the fee structure that governs the fees charged by High Court enforcement officers? I think this is probably one for you, Chris.
Yeah, thanks, Vic. So as we've said, we don't charge a fee for a virtual visit. The master in the court proceedings considered the fee structure, the taking control of goods fees regulations, and that sets out the procedure which may be followed. And the reason I pause and say may is because the wording of the legislation is that these are fees that may be charged as opposed to must be charged. So as such, there is no formal obligation upon the relevant High Court enforcement officer to charge those fees. And we considered this at great length in the early part of last year. And we recognised that there was a significant cost saving because an enforcement agent wasn't physically travelling and spending time physically attending premises, and recognised that a virtual visit would be much more straightforward in terms of travel time, for instance. And we recognised that cost saving, and that's how we concluded that we weren't going to charge a fee for the visit.
That's great. Thanks, Chris. So we're over time, but I think we'll just do one more question. It's a good one. How do you successfully verify the goods? How do you ensure you are not tricked? So any takers for this one?
I'll answer that one, Vic. So through our substantial testing we have been doing, clearly there's identification and verification that we're doing of customers both at head office level and then virtually through through use of photo ID and utility bills, bank statements, that type of stuff. The testing we've done has shown really successfully the use of smartphones and tablets in asking the customer to show them around their home, show them goods, show us barcodes, serial numbers, demonstrating the quality of goods. To the extent of the anecdotal feedback I've had from the enforcement agents, and these are the guys and girls that are seasoned professionals in this. They've done this in real life for several years, anecdotally give us real confidence of their assurance of that process. So yeah, we've got high levels of confidence there.
Great, thanks Nat, and a great set of questions from everybody who's joined us today. So I'm aware we're over time, so if you want to know more about virtual enforcement, you can contact clientmanagement@justdebt.co.uk, and we will send this presentation out after the event. We'll also be sending you what is virtual enforcement, and of course we'll send you out all the questions that were asked today with our response to that, and there'll be additional frequently asked questions that we've also tried to preempt that you may have wanted to ask or after the event. So thank you very much for attending our webinar today. Please get in touch with Just if you've got any questions or would you like to know a little bit more about virtual enforcement. Thank you.
Okay, thank you everyone.